Hi, welcome everyone, and thank you for joining our webinar today on the Employment Rights Bill. We have about an hour booked for this webinar, so we'll spend about 30 minutes on the presentation before moving on to some questions at the end. So you'll see from this title page that this webinar is being held under our new company name, which is Impact HR. We are still the same company, but we have a new name, and as we move towards the end of the year and into 2026, we will be sharing more about Impact HR with you. So some introductions. So I'm Juliet and I'm a new face here at Impact HR. I've joined as the Director of HR Operations. I am joined by Grace Rogers as well, who will be supporting me in the background and collating all of your questions. We are using GoToWebinar to host this webinar today. So for those of you that haven't used it before, you are all muted and we can't see you. So hopefully you can see us and hear us okay. Please type any questions that you have for me on this topic as we go through the session. And depending on whether you are using the web version or desktop version, you can navigate to the relevant part of the app to ask these questions. We will try to answer as many questions as we can at the end of the webinar, so please put them in that section. We shall also be asking you some questions today via some polls. So when we get to that section, there'll be a pop-up on the screen for you to choose the relevant response. So I wanted to introduce you to us here at Impact HR. Our focus is on delivering HR solutions that are genuinely tailored to your business. We understand that no two organisations are the same, whether you are a small or medium-sized enterprise looking to scale up, or if you are a larger company aiming to refine and improve existing HR processes, we can tailor and work to your needs. Our services are designed to be flexible and comprehensive. We support you in enhancing operational efficiency, as well as staying compliant with employment laws and regulations, and ultimately freeing up your time so you can focus on what matters most, which is growing your business and focusing on your people. So we understand the real challenges that SMEs face when it comes to managing people. Our reputation here is built on deep expertise, hands-on support, and real results. So whether you need a new employee handbook or employment contracts, or someone to chair a disciplinary or capability meeting, or even just guide you through a redundancy or a change consultation, we are here to help. We can work on a retained basis or work with you as pay-as-you-go or on a project basis. And as mentioned, our services are bespoke, so if you are considering a retainer, we understand that one size doesn't fit all, and we can tailor these solutions to meet the needs of your business. So looking at the aims and objectives of why we are here today, it's essentially to demystify the Employment Rights Bill, highlight the major changes that are proposed, talk through the timeline as we know it today, and provide some tips of what organisations can do to prepare. So the key learning objectives are to understand what is changing, know when the changes are expected to come into force, identify the implications for organisations and HR to prepare, and outline some practical actions that you can take away. So I wanted to explain why this bill matters. So the government has described this as a once in a generation overhaul of the legislation governing the employment relationship. The main aims of the bill are to increase job security and address exploitative practices in employment and modernise industrial relations. The bill is drafted to be very pro-worker, and therefore there is an impact on cost and an administrative burden on employers. So there is a risk here that must be understood. We are therefore encouraging proactive preparation rather than reactive compliance. And this webinar today will give you some takeaways of ideas that you can put into action. So the current status, so the bill is going through Parliament. However, we are in a state of that parliamentary ping pong that we have all heard about now, where the details of the bill are being debated between the House of Lords and the House of Commons, trying to reach agreement. But there are a few areas, and mainly the main areas, that remain in dispute. So royal assent of the bill was due in the autumn of 2025. However, with the ongoing debate on some of the major points, this timeline has slipped already, which will have implications on the rollout of the provisions of the bill. There is a timeline for implementation that begins in April 2026 and continues right through to 2027. And while some changes are not immediate or even confirmed as of today, they are significant, so planning needs to start now. As the provisions of the bill are still going through Parliament, some details may change and some measures will be dependent on secondary legislation and consultations that will come later. So what we talk about today is what we know as it currently stands as of November 2025. So before we begin, we want to share a poll with you in the audience to let us know how prepared do you feel your organisation is for the changes through the Employment Rights Bill? Do you feel very prepared, somewhat, not very, or not at all prepared? So we'll just put a poll up then for you to answer. Okay, I can see there's some answers coming through there. So 61%, 60% of you are saying somewhat prepared, 23% not very prepared. So this is probably exactly where many organisations currently sit, where you started taking some steps, but perhaps you are still unclear on the finer points or the timing of certain changes. So what we'll do today is clarify what's coming when, highlight the highest risk areas for employers, and give you a clear action plan so you can move from somewhat prepared to fully prepared over the next few months. So thank you. If you want to close the poll. Thanks. So now let's have a look at the key changes. So the key changes that we'll be talking through today include unfair dismissal becoming a day one right, 0 hours contracts and guaranteed work, flexible working requests, family-friendly reforms, and then tribunal reforms and reporting requirements. There are lots of other topics within the Employment Rights Bill, which I will talk through briefly at the end of the webinar. So now we've looked at some of the key changes, I would like to take another poll for you to answer. So which part of the Employment Rights Bill concerns you the most? Would you choose from the day one, unfair dismissal rights, flexible working, 0 hours, or the increased enforcement by the Fair Work Agency? So if we can have the second poll, please. Great, thank you for your responses there. I can see the majority there then is the day one unfair dismissal rights, and it's not really a surprise. This one is the biggest sort of structural change for employers, especially SMEs. There are still lots of question marks around what this will look like in practice, which might be causing some of that uncertainty amongst employers, but let's have a look at that then today. I suppose the concerns amongst employers reflect the breadth of the Employment Rights Bill and reinforces the need for a strategic and staged approach to implementing new ways of working just to remain compliant. So let's have a look at each section in a bit more detail. So unfair dismissal becoming a day one right, what is changing? So employees will be protected from unfair dismissal from day one of employment, rather than having to have a 2-year qualifying period as it is currently. There is a proposal for an initial period of employment, which is designed to be like a new statutory probationary period. And this has been suggested to be a period of up to 9 months, but is still to be confirmed in terms of duration and what it actually means for employee processes. So when it is expected in 2027, and whilst this is sort of furthest down the line in terms of expected implementation dates, it is one of the key pledges made by the government and one that has caught the attention of most employers in the country. However, it is one of the points that is still being contested in the House of Lords. So what this means for employers, potentially greater risk from early termination decisions. Currently, employers have that 2-year period to make a decision, in most cases with relatively lower risk. However, this will no longer be the case, as every termination decision will carry risk for the employer to consider. There will be a potential increase in legal disputes and tribunal claims. There will be many more people in the workforce who have the right to raise an unfair dismissal claim against their employer compared to the number that there is at the moment, just due to employees currently having to wait until they have worked for 2 years continuously to have that right. Probationary periods may remain, but will become more important. So whilst we are waiting for more information about that initial period of employment, it is suggested that this may be a period of 6 months or 9 months, which means that employers are likely to set their probationary periods at 6 months, for example, and review the suitability of new starters accordingly in that time frame. Performance management processes and documentation will become critical. So if making a termination decision, employers will need to have a strong reason to dismiss based on sufficient evidence to back up their decision. So what actions can we take now? So we're advising here to review your current recruitment and selection processes, just to ensure that you have robust processes in place to make the right hire in the first place, with a view to reducing the need to terminate any new hires. Also, audit existing probationary period processes that you have. Review what you have in place currently. What is the length of your probationary period? Is it shorter or longer than what the government is proposing? Are your managers holding review meetings, or do you hold probation review meetings at all? So update any documentation that refers to probationary periods and the process that is followed. We are also advising here to develop performance review frameworks to provide a structure around the performance management process that is simple to use for your managers. 1, to support and develop your people, but 2, in case you need to refer to this for any termination decisions. Training managers on handling performance from day one. So this is going to be key. It won't matter really if you have the best process and framework in place if your managers are not trained in how to work within it sufficiently. So train your managers on the process for dismissals to ensure they are handled correctly. Ensure your managers are trained in the process that they must follow to reduce risk in termination decisions in terms of following the process and documenting the process, but also ensure your managers can seek advice from experts such as us here at Impact HR to ensure that they are following the correct steps. So a core part of our service is to provide advice to organisations to ensure compliance in these situations. So looking now at the next key theme, we have 0 hours contracts and guaranteed work. So what's changing here? So 0 hours workers will be entitled to request a guaranteed hours contract to reflect regular working hours. This will be based on a reference period, which is still to be confirmed, but likely to be a 12-week period. 0 hours workers will be entitled to notice and pay for any short notice shift changes. And again, there are still some unknowns about this. We don't know as yet if that reference period, what it will be set at, how regular the hours will be determined in practice, and what reasonable notice of a shift change might look like, although we think it's likely to be 7 days, but still to be confirmed. So when it is expected in 2027, so another one that is further down the line, but is a concern for employers, especially those who rely on 0 hours workers, such as those in the hospitality or the care sectors. It is important to note that this part of the bill doesn't ban 0 hours contracts completely. Instead, it looks to tackle those situations where they are perhaps exploited by employers, leaving workers with a lack of job security and financial security. This is also a point of the Employment Rights Bill that has elements that are being contested in the House of Lords. So here at Impact HR, we are keeping our eye on what happens with this. So what does this mean for employers? It may result in there being more employees on guaranteed hours contracts. So for those sectors that rely on 0 hours contracts, this could reduce the flexibility that they have had in the past. It means more proactive planning of shifts and rotas will be critical, as employees will need the minimum notice of any shift changes and they would be able to refuse last-minute shift changes if they were not given the required notice. Workers would also be able to claim compensation from the employer for any last-minute shift changes, which is another area for a potential additional cost added to organisations. And there's increased administrative burden setting the rota, ensuring staff availability, cover, tracking hours, and then managing those claims for compensation if it does occur. So actions to take now, we are suggesting organisations to review who is currently on a 0 hours contract and what their working pattern is. Is anybody working what may appear to be regular hours? Consider whether this kind of contract is still suitable for their working arrangements, as things may have changed over time. Review your current shift patterns. Do they cover what you need? Are you changing shifts at the last minute? What could be put in place to avoid this, if so? Also advising to review what systems you have in place to track and monitor hours that are being worked. If the reference period that is being talked about is set at 12 weeks, would you have the mechanisms in place to track this and identify any workers who may be able to request guaranteed hours? So consider at this point whether you need to implement a new system or upgrade a current system to cope with the increased requirements. So here at Impact HR, we partner with Breathe HR to support our clients with a HR system. And Breathe has a rota and time and attendance functionality that can track and manage this kind of information. Moving on to the next section then about flexible working requests. So flexible working is set to become the default option, where employers would be expected to look at how a flexible working request could work in the first instance. So this is going to place more responsibility on employers to approve requests unless they have a valid business reason for refusal. So changes were already made to this back in April 2024 for the right to request flexible working to become a day one right, and also to increase the number of requests employees can make each year from 1 to 2. This is a further step, though, to place the onus on employers to accept the flexible working request as the default position. And if they do have a valid business reason to decline the request, to then work backwards from the default to show how it would not be suitable for the role. So this is also expected in 2027, with consultations on this set out to begin from now, so from winter 2025 into early 2026. So what does this mean for employers then? It could mean an increased request rate for hybrid working, fully remote working, or varied working patterns from employees. This may potentially create more complications for those managing workforce planning for shifts, rotas, cover, etc. And there are going to be some roles where flexible working just simply won't work practically. However, it may also be seen as an opportunity for organisations to attract and retain talent by promoting flexibility within your workplace. So this will be dependent on the type of sector your organisation is in and the needs of the role itself. But working practices since COVID have moved on significantly in regards to flexible working options, and the workforce has a level of expectation now for some kind of flexible hybrid working. Some actions to take now. So we are suggesting to review your current policies on flexible working and assess whether they are up to date since the most recent updates to legislation, and ensure that they are adaptable to the new way of working when this comes into force. Be mindful that discussions around flexible working may begin during the recruitment stage, so you may want to reflect this in any recruitment policies that you have too. Assess your capacity to manage flexible working requests against the workload and also business continuity, given that there may be that influx of increased requests. Implement clear processes and decision-making frameworks for handling flexible working requests. So again, ensure that you have clear documentation and a process set out for managers to follow should one of their team members submit a flexible working request. Would your managers know what to do if they did receive one from a team member? Consider again what systems you have in place to track flexible working requests to ensure that they are being managed and processed within the 2-month timescale as set out in the current legislation. So this is another example of data and process management that Breathe HR can support organisations with. And finally, train your line managers on the flexible working policy, the procedure and the process to ensure that they follow the process your organisation has set out to be in line with the legislation in terms of the timeframe and documentation, but also to have strong and robust evidence-based reasons to decline a request should that be the conclusion. So here we're advising really to look at changing the mindset around the approach to flexible working requests from an immediate answer of no to yes, how can we make this work? And make use of the tools at your disposal in this process, such as trial periods to demonstrate that you are willing to give it a go and see how it can work in practice, or other options to meet the employee part way with their request. So one of the next key changes that we're looking at is around family-friendly reforms. So one of the updates is that paternity leave will become a day one right, removing the current requirement to have 26 weeks service. Also, unpaid parental leave is going to become a day one right too, removing the current requirement to have 1 year service. And for those two things, we know that they are expected as early as April 2026 next year. However, there are some other proposals within family-friendly reforms too from 2027. So the government is also reviewing carers leave. And as we know, this came into force in April 2024 to provide carers leave to those carers in the workforce. But the updates are to consider introducing paid leave as it is currently unpaid. However, this is another point that is to be confirmed. So we are keeping an eye on that. Another update is around bereavement leave. So it's proposed to be a day one right, allowing employees to take at least 1 week of bereavement leave. It is unknown again at this stage if the leave is going to be paid or not, still to be confirmed. And an increased entitlement of parental bereavement leave to provide for 2 weeks statutory bereavement leave for parents who experience pregnancy loss before 24 weeks, as this is not currently covered. And additional protections against dismissal for a pregnant woman when she's pregnant, on maternity, or within 6 months of returning, with some exceptions. So this is likely to also cover those on adoption leave and shared parental leave. It is not yet clear what those exceptions might be though, but it may include cases of genuine redundancy, for example, when there's a business closure. The principle behind this proposal in the Employment Rights Bill is to enhance job security for new and expectant mothers. So what this means for employers then. So more employees will be able to take time away from work on family leave, as more people will be entitled to the options for leave from day one of employment. There may be a potential increase in short-term or unplanned leave, just due to more people being eligible for paternity leave, parental leave, and carers leave. It could place an additional strain on those covering the absences of colleagues, especially for smaller organisations, which highlights the need for sufficient workforce planning and cross-training just to ensure that you've got adequate cover of the work. But again, this could also be seen as an opportunity to review your organisational culture to embrace family-friendly ways of working and use it as a way to attract and retain talent. Some actions to take now. So again, here we are advising to review your family-friendly policies to reflect the new legislation. For example, removing the requirement for the length of service to become eligible. Review your systems to ensure that they capture and monitor leave dates, ensuring staff have a simple way to request their leave, for managers to review it and also manage it across the team so they can easily see who is available or who is on leave at any one time. Review your processes around restructures and redundancies to ensure that they include the safeguards to identify any new or expectant mothers so you don't fall foul of the update in legislation. Also, train your line managers in the updated processes in how to handle the new leave requests and ensure that managers understand the enhanced protections and therefore properly handle the leave process with their team members, including the return to work stage as well. And also communicate the updates to staff so that they are aware of their rights in relation to family leave options, how they request it, and what timeframes they need to work within too. And moving on to tribunal reforms as part of the bill. So what's changing here? So the time limit to bring an employment tribunal claim is increasing to 6 months. So it's increasing from 3 months as it is currently, plus any extension afforded due to the early conciliation stage, which, as we now know, is also increasing, separate to the Employment Rights Bill, from 6 weeks to 12 weeks as of the 1st of December 2025. The Fair Work Agency is a proposal from the Employment Rights Bill who will have powers to bring tribunal proceedings on behalf of workers. And all of this means that there will be a more stringent obligation on employers for record keeping in order to defend any such claims that are made against them. So this change to the Employment Tribunal timeframe is expected from October 2026. So this time next year, it will be in place. So what does this mean for employers then? An increased likelihood of tribunal cases and therefore costs. With a longer period of time for claims to be raised, employers may be waiting longer to know if they must defend a case. An increased requirement for record keeping on things like holiday pay, leave, shifts, etc., as the requirement is to keep this data for up to 6 years, which is a significant administrative burden. An enhanced scrutiny from the Fair Work Agency. So prepare for transparency, as the Fair Work Agency will be reporting on and also publishing their work, which means that non-compliance could become more visible. So actions to take now. We are suggesting to review your current processes to ensure that they are compliant to mitigate potential disputes. So how can your current processes be enhanced to foster a positive working environment, to reduce the number of disputes, but also to deal with them robustly to resolve them before they escalate? Review your policies to ensure that they are robust in how the organisation handles things like grievances and internal appeal processes, to encourage early resolution of grievances and through appeal processes to reduce the number of claims that actually may end up in tribunal. Again, train your line managers in handling disputes, making them aware of the potential risks and how claims might arise. Equip your line managers with the skills to follow a fair process and document what they do, just to put the organisation in the strongest position should a claim come through. And ensure your systems are up to date to store and retrieve that relevant data that may be needed at future points in time. So identify what records you keep, how long you keep them for, and whether they meet the new expected standards. Consider implementing or upgrading your systems to ensure that they support with long-term data storage, reporting, but also easy data retrieval in the event of a claim. So those were the key parts of the bill that I wanted to talk through today. But as I mentioned, there are some other proposals within the Employment Rights Bill that we will just look at now briefly. So they include things like sick pay. So with the change for statutory sick pay to be payable from day one and removing the lower earnings limit eligibility criteria. Trade union reform, simplifying the trade union recognition process and making it easier for employees to access trade unions in their organisation. There's also collective consultation during redundancy, which is increasing the protective award available in collective redundancy processes, and also reviewing the threshold of 20 or more redundancies proposed at one establishment, which again is all to be determined and is being discussed. There's the proposal for gender pay gaps and menopause action plans. So this will be a requirement to employers with 250 or more employees to publish action plans on gender pay gaps and menopause. So this will be voluntary to begin with before becoming mandatory later on. There's fire and rehire, another one of the big proposals from the government that met the headlines, restricting the employer's ability to use dismissal and re-engagement practices where there is a failure to agree to a variation in terms. Also an update to sexual harassment, so requiring employers to take all reasonable steps to prevent sexual harassment in the workplace, which is an enhancement to what the legislation says currently when it refers to just reasonable steps. Protection from harassment, which would be then introducing third-party harassment as well. Ethnicity and disability pay gap reporting, so again mandatory reporting for employers with 250 or more employees. And extending equal pay rights to ethnic minority workers and disabled workers. So as a wrap up of today's session, I wanted to bring everything together really into a clear set of practical next steps for all of the main points that we've talked through today. So these are the actions that will help you prepare confidently really for the Employment Rights Bill and reduce risk across your organisation. So firstly, to look closely at your recruitment, selection and probation processes. Make sure that they're structured and consistent and well documented from day one. Develop simple performance review frameworks and invest your time in training your managers so that they can handle early performance conversations and dismissals correctly and fairly. Second, for organisations using 0 hours or variable hours working, review who is on these arrangements and what their actual working patterns look like. Check your shift patterns and ensure that you have systems that can accurately track hours, cancellations and notice periods. So this will be critical for compliance moving forward. Third, to revisit your flexible working approach. Update your policies to reflect the move towards flexible working as a default. Assess your operational capacity and create clear frameworks for decision making. Line managers will need confidence and clarity, so training them on the new process is going to be essential. Fourth, to update your family-friendly policies in line with the new entitlements. So review your systems to ensure that they can properly record and monitor leave, and make sure that managers understand the new requirements coming through. Also, some clear communication with staff to help manage expectations and support a smooth transition into managing leave within the new framework of the new legislation. And finally, strengthen your dispute resolution and compliance processes. Review your grievance, your appeals and record keeping processes so that they can withstand scrutiny from tribunals or the Fair Work Agency when that comes in. Train your managers in handling disputes early and appropriately, and ensure your systems can securely store and retrieve the information that you might need. So taken together, these steps form a strong and practical roadmap. They will help you stay ahead of the upcoming changes, reduce risk, and build a more resilient and compliant organisation in the months and years ahead. So just before we move on to questions, after this webinar, you will receive a follow-up email that will include a link to the webinar recording if you wanted to listen back to any sections that are of interest to your organisation. We will also share a link to our Employment Rights Bill checklist that gives you a clear summary of the main points that employers need to be aware of, what the impact might be to your organisation, and what action points you should be taking now to prepare, so similar to what we have talked through today. We will also share our contact details should you wish to get in touch with us or discuss any ways in which Impact HR can support your organisation with anything that we've talked about today within the Employment Rights Bill or HR or employee queries in general. So, question time. Do we have any questions?
We do. We've had quite a few come through whilst you've been speaking about it, Juliet. So the first one I'll start with is, if a new starter is not working out, what does the process look like, or what will it look like to manage this in the initial period of employment?
Yeah, well, I think the first answer is we don't know fully yet. We are still waiting for all of the details to come through. What we do know is that there's been talks about that initial period of employment, like similar to a probationary period, possibly 9 months, but we're still waiting to know the details. And I would suspect that the process would be something similar to what we do now for employees who have more than 2 years of service. So it would be sitting down with them, putting the concerns to them, letting them discuss and hearing any mitigation from them, ensuring that we've gone through some support and ensure that they've had their training, and then coming up with a conclusion. So there will be more steps to follow. It won't simply be a case of having a meeting and being able to terminate employment at that point. So yeah, more steps to follow, but just to ensure that the employer is protected, and again, it gives that more security for the employee.
Okay. Thank you for that. Another one we've had is with the changes to 0 hours contracts, if a worker has been working regular hours and are entitled to move onto a guaranteed contract, do they have to?
Do they have to? So no, they won't have to. But they will have the right to request to move on to a guaranteed hours contract if they meet that criteria. I suppose here it's useful to note that 0 hours contracts, they can work for people in different circumstances. It might work for their lifestyle if they have other commitments. So if they do meet the criteria and they request it, then it is something then that the employer would have to respond to accordingly. But essentially the decision would be down to the worker if they wanted to request a guaranteed hours contract or not.
Okay, brilliant. And just on the back of 0 hours as well, we had another question. So you spoke about pay for short notice shift changes. What do you mean by pay for those short notice shift changes?
Yeah, so again, we are waiting on all of the details, but if a shift was changed within short notice, and again, the likelihood is that that would be like a 7-day period, but to be confirmed. If it meant then that the employee would miss out on a shift because the employer had changed it at short notice, then the employee would be entitled to claim compensation for missing out on their shift, which again, I presume would be compensation if they had worked it, what they would have been paid. But again, this is what we're waiting for the details on as to what that process would look like, as to how they would claim that compensation and what the compensation would look like.
Thank you for that. Just on flexible working, so someone's asked, will they still be able to refuse a flexible working request if it doesn't work for their business?
Yes, so we have the 8 statutory reasons that are currently in place to decline a flexible working request if it's not going to work, and that will still be available to you. So, for example, the inability to meet customer demand or the burden of additional costs on employers. So employers would have to set out their decision to decline the flexible working request using one or more of those 8 reasons, as we do now. However, there will be the additional requirement for employers to explain why their decision to decline it is reasonable. So we need to make sure in that case it meets the test of reasonableness, i.e. what would a reasonable employer do in that situation, and ensuring then again that we've used one of the statutory reasons, but also taken that extra step to ensure that the reason to decline the request is reasonable too.
And is it looking like the 8 standard, the reasons for rejecting a request will stay the same, or is it looking like that might vary, or not vary, but if there might be more coming across from what they're saying?
Yeah, as far as I know, it's looking like they're going to stay the same, and they've been in place for a while, and hopefully employers are familiar with them. But again, it's just going to have the extra element to declining a request is, well, is it reasonable, and ensuring that everything has been considered before coming to that conclusion.
Oh, okay. Thank you. Someone else has asked, do we need to update our policies straight away?
No, not straight away, as each section of the bill, it's got an implementation date of when it will come in. And again, we are waiting for all of the detail in order to make those updates as well. But I suppose the advice is do start reviewing them straight away. One, to understand what you've got currently and is it up to date, and then also to know where the gaps are, to know what needs to be updated, so that the updates can be planned in to go as smoothly as possible, as and when we get the details and the implementation dates for when these come in. And I'll just add here, I suppose, for those of you on the webinar who are clients of Impact HR, please do get in touch with us if you haven't done so already, because we can support with that process to ensure that your documentation is being updated.
Last but not least, so if anyone does have any more questions, please do ask. This is the last one for now. Someone said there are a lot of updates to take in. How can we best prepare for this without overwhelming our line managers?
Yes, yeah, good question. It is there is a lot and it can be quite overwhelming. So I think what I'll say here is your managers early and roll out some training and awareness of all of these updates, like in stages, starting from now if you haven't already. And again, then going back to your policies, make sure that they are being reviewed and that they are being updated and your procedures are being updated and everything's being set out as clearly as possible for your managers to sort of pick up and use a process or a framework or documentation that you might have in place for anything that they need to do when managing their people. Also, similarly, then updating your systems to ensure that managers can do things like record keeping, to make it easy as possible for them really in their busy day-to-day lives. And I suppose plan a communication strategy for your line managers over time. So say this whole thing is being implemented from now to 2027. So we've got a good long time for this to run through. But also some communication for your employees so that line managers and your employees are all aligned in what's coming through. And equip your line managers as well with some pre-prepared questions perhaps that employees might come to them and ask so that they know what to go back with and that you've got a consistent approach as well. So really just to have all of this information on hand and give it to them in sort of like a bite-sized fashion for them to take on board and refer to as we go through this long process.
Great. Thank you for that. That is all the questions for now, but obviously if there's any that sort of come through whilst you're talking through, I'll shout.
Lovely. Thank you very much and thanks for your questions. Okay, so next we are planning a series of webinars and we would like to hear from you on what you would like us to cover. So we have a few options up on the screen. So I've got another poll for you. So please do add your votes to the following options. Would you like a webinar on employee engagement, HR challenges that we might face in 2026, HR technology and AI, a general employment law update, or would you like more on the Employment Rights Bill? As we've seen, there is a lot to cover. So if you want to cast your votes now. Lovely, thank you very much. So we've got a bit of a mixed bag there. I think we've got votes for everything. HR challenges in 2026, I think, has come out the top, general employment law update. So that's great. We will then take this away and put in place a plan then for our webinar series for next year for you. If any of the topics that you would like us to cover weren't on the list that would be of interest to you, please do get in touch with us because we do want to cover things that are going to be useful for you. So before we go, I just wanted to highlight some of the useful information that we have on our website, which is impacthr.co.uk. And it includes lots of free tools, such as the Employment Rights Bill checklist that I've mentioned throughout the webinar today, that can be shared with you. But we also have a HR benchmarking assessment. So this can evaluate key areas of the HR function and understand the areas that may be needed to enhance compliance, efficiency, and an overall employee engagement. And that is a free tool available to you. We also have a sexual harassment risk assessment. So this is one of the tools advised under the legislation to prevent sexual harassment in the workplace. And this assessment can help to uncover any potential vulnerabilities, and reduce any risks, and enable you to implement instant steps really to safeguard employees and your organisation. And on our Impact Hub, you will also find our webinar archive, as well as all of our latest news and updates. So this webinar will be recorded and saved on there, and all of our previous ones as well. So we also wanted to share with you that here at Impact HR, we understand that some HR issues require more than just day-to-day advice. So we do offer hands-on support for those more sensitive or high risk or strategic people matters, from restructures to TUPE transfers to risk assessments or performance management processes. So whether it's a one-off project or part of a wider change, we can be here to guide you every step of the way. And on this slide, you will see lots of examples really of those different projects that we can support with. If you would like any support with any people matters that you have ongoing at the moment, or if you want to put in place some proactive measures to prevent any issues arising, please do get in touch with us. And I'm just sharing our contact details here for you. Were there any further questions, Grace? Did anything more come through?
Nothing else has come through, so yeah.
Lovely. Well, here are our contact details. So if you have any questions that you want to raise with us afterwards, please do get in touch. And I hope you found it useful today. And just want to say thank you. Thank you for joining us, and also thank you for joining in on our polls and asking some of those great questions today.